Welcome to the Business of Family, the podcast where we explore the stories, challenges, and opportunities of family businesses. I'm your host, Tammy Buss, and I'm a family business survivor, and I'm also a family business advisor. In this show, we'll be talking with family business leaders and experts to bring you insights and inspiration so you too can survive your family business journey. Whether you're a founder, a successor, a professional, or just curious about family business, this podcast is for you. So our guest today is Kim Cura, and Kimberly is a partner at Lerners, which is a law firm here in London, Ontario, and she's a litigator. And not only is she a litigator, but she is a mother of 2 girls and a dog called Oreo. So it's got to be black and white?
He started out black and white. He is now gray.
He is now gray. Oh,
yes.
So you have to change his name. But anyway, thank you for joining us today, Kim.
Thanks for having me.
So tell me a little bit about litigation. So you're a litigator. Tell me a little bit about what that is.
So litigation essentially means that I go to court. We have lawyers who are solicitors, and they do the more transactional work. So, signing wills, helping set up businesses, that sort of thing. Those are the solicitors. The litigators, like me, go to court. And we also do things like alternative dispute resolution, so mediations, arbitrations, that sort of thing.
And so you're here today to talk a little bit about state litigation, because as a family business advisor and as a family business podcast, we like to talk about all things family business related. So tell me a little bit about estate litigation when it comes to family businesses.
So estate litigation is a very broad practice area in terms of there's lots going on. We have your will challenges, which is what people typically think of when they think of estate litigation, but we also have power of attorney disputes.
Okay.
Those have been on the rise since COVID. We can talk about that later if you like. But power of attorney disputes, guardianship applications, dependent support claims, and now something very exciting is happening in the estate litigation world with the new substantial compliance provision under the Succession Law Reform Act, which is where the court now has a power to validate a will that has not complied with the formal requirements. So, for example, a will has to be written, typically. It has to be witnessed by 2 people. It has to be signed at the end by the person making the will, or the testator, as we call him. But now with the substantial compliance provision, the court now has the power to validate a document that has not complied with those formal requirements. So that's a new sort of burgeoning, exciting area in this practice area.
Exciting, I guess, for a litigator, not so exciting if you're on the other end of
it.
Exactly.
Yeah, exactly. Yes.
So, from a litigation standpoint, when someone's going to court or, you're fighting, what are some of the things that you should be thinking about as a family, as a person, as a family business? What are some of the things you should be thinking about to kind of avoid hiring you? Like, there's estate litigators for a reason. So how can we avoid actually hiring you?
What I usually say is robust planning as well as communication. So the planning part is you want to update your estate planning regularly, and at the minimum after every major life event. You got married, update your will. You've had children, update your will. Your children are now the age majority, update your will. You've had a divorce. You are in a new relationship. All of those major life events, you want to continue reviewing your estate planning, because all of that has an effect on how your estate is distributed when you die. And then the other piece, which goes into the litigation sort of component, is that you want to be communicating your wishes consistently, clearly to your family members. I can't tell you, Tammy, how many cases I've had cross my desk where clear communication from the person making the will would have avoided a whole bunch of heartache for the family and litigation costs.
Right.
So especially with the listeners of this podcast who are running their family businesses, and family businesses are complex structures. You have the family dynamics, but then you also have the business side of things that can complicate things. So clear communication from, say, parents passing things down to their children would be very, very helpful.
Yeah, and we talk about that with our clients, and we have a lot of family meetings, and we're talking about the fact that you can't, it's better to have the discussions when you're alive and your reasoning for what you're doing. Your family doesn't necessarily have to agree with what you're doing. They have to understand why you're doing it, because you can't change it or explain it after you've passed.
Exactly.
Right? So what are some of the more popular sort of reasons that families go to court?
In the estate litigation
Yeah.
piece, yeah. There's your will challenges, but as I alluded to earlier, there's the alarming rise of power of attorney disputes. So what we've seen from COVID, where everyone was isolating, and an elderly parent would often isolate with one child versus another.
Right.
And then over the course of time, spending time with that child, sometimes a parent will think, well, you've been here, you've been helping me more than your sister or your brother. I'm going to put you on my bank accounts as a joint owner, or I will redo my will so you get a disproportionately larger share than your sister who hasn't been here or your brother who hasn't been here, etc. And also, sometimes we find that parents of a certain age they're weary of managing their own finances, making their own decisions, so they'll ask for help from a daughter or a son. And sometimes that can raise red flags for other family members. And then we end up in a situation where the person named as an attorney for property is being sued by a brother or a sister or what have you for alleged misconduct or misappropriating mom or dad's assets, mishandling them, et cetera, et cetera. And some are just, it's family dynamics and there's misunderstandings and miscommunication. And other times, alarmingly, it's actually the case that there's misappropriation.
Right.
Yeah. So there's that, and then there's your will challenges where somebody will challenge mom or dad's will on the basis that they didn't understand what they were doing. We call it lack of testamentary capacity in my world, or that they were quote unquote unduly influenced by somebody who benefits disproportionately under a will. And then there's also your guardianships. So, for example, and this is where planning comes into play, if you don't have a power of attorney, a validly executed power of attorney in place, a family member or somebody can apply to the court to be appointed as your guardian if you are no longer capable of making those property decisions or personal care decisions, that sort of thing. And then there's it's a fun area.
It's a fun thing, yeah. Right. Disputes. Now, when you're in a family business, you have the business itself, which in some cases is the largest asset that you have. What are some of the common, or have you seen some of the worst case scenarios that happen with a family business that maybe, the will wasn't properly executed or was older, or, one sibling thought they were getting the business and the other one didn't, or there wasn't enough assets left? Like, what are some of the issues that come up, and sort of how do you kind of avoid them?
Yeah, so one of the issues that this goes back to the updating your estate planning regularly. So if you have an old will that doesn't say refer to new aspects of the business, then the family's left to wonder, okay, so what happens? What happens to these shares? What happens to these assets, etc.? Other issues that might come up would be if there isn't any robust planning in place in terms of taxes, for example. What happens when these assets pass to the beneficiaries and then the estate is taxed for
liable.
It? Yep, liable. There's also creditors that, if you've run into an issue where you're owing your business is owing a lot of money to a lot of creditors, and you haven't communicated that to the beneficiaries, then you're run into a situation where you die, and then all of these creditors come knocking on your door, and then there isn't much left in the estate to distribute to your beneficiaries, that sort of thing.
Right.
So it really goes back to that planning piece.
So what happens if you do decide that you wanted to give a disproportionate amount to one child versus another? Maybe it is the business because they've been involved in the business for 30 years and you do want them to have the business and, you know, the other family to divide the other assets. So it is not, it's in their mind it's fair, but not necessarily equal. Like what happens there? How do you say, no, this is what I really want?
So ideally you see your estate planning lawyer and you give them clear instructions on what you want. And that is clearly documented in the lawyer's file. Ideally, you then communicate, then this is the second part of the sort of like piece here, is that you communicate your wishes to your children while you still have while you're still of sound mind.
Right.
Yeah. And ideally, in a perfect world, the lawyer's file will document all of that too. Like, I met with Tammy, and this is how she wants it done, and these are the reasons why, et cetera, et cetera. So if it's a disproportionate sort of estate planning, then your reasons for doing that have to be documented. They have to be communicated to your family members. And ideally, the lawyer will also advise the person making a disproportionate sort of distribution that it is possible. So this is sort of the other area of estate litigation we haven't talked about yet, where there are dependent support claims.
Right.
So even if you've disproportionately distributed your estate, there is a mechanism under the Succession Law Reform Act, which is the governing legislation in Ontario, for your dependents, put that in air quotes, for your dependents to make a claim saying, Mom disproportionately distributed her estate, but I am a legal dependent of Mom, and so I deserve to have a little bit more than what I got under the will. So yeah, there's that communication and the planning piece, but also being aware that if you don't address all of the possible claims that could be made on your estate, then there's a dependent support claim that could be brought when you die. And
it becomes, you know, it's like you're trying to get your wishes across. A lot of clients don't really want to talk to their family about what they're doing. You know, they feel, well, these are my assets. I want it distributed the way I want. But unfortunately, then there is fighting that can happen amongst the family members when they realize that maybe they weren't getting what they thought they were going to get. Or somebody got more and they're like, well, I don't think that's very fair. So I don't know what, you know, communicate is so important, but what other mechanisms, if you don't want to talk to your family about it, is it just the documentation in your file and in the lawyer's file? If you say, look, I don't want to talk to my family about what this distribution is going to be, or, you know, I'm leaving it all to charity. I mean, what happens if they say that? I don't like my kids, I'm leaving it all to charity. Like, how do you get them to talk, and what can you do if they won't talk?
I mean, there's that saying, you can only lead the horse to the water, and if the horse decides to drink. I mean, yeah, as from an estate planning perspective, as a lawyer, all you can really do is advise your client. Look, this is what happens if you make a disproportionate distribution under your will. These are all the possible claims that your children might bring, or not children, but potential beneficiaries might bring after you die. And then after that, it really is up to the person. And that's sort of the unfortunate reality. It's also human condition too. Families are complicated. Very
complex. I mean, not only is a family complex, but when you throw a business into it, it becomes even more complex. So what is the process? So tell me about the process. So mom or dad's will was read. I didn't get the business. I thought I was getting the business. What is the process to actually start this whole mess? Because that's really what it's going to be. It's going to be such a mess. There's going to be, you know, families torn apart. It just becomes, you know, then emotions get into play. It's not even factual. It's more, you know, emotion, and then, you know, all bets are off, right? So what is the process?
Yeah, so if a will challenge file lands on my desk, the first thing I want to do is to read the will. What does it actually say? The next thing I want to know is if this will was prepared by mom or dad's usual estate planning lawyer. Because sometimes red flags can, their alarm bells can go all over the place when it's not your mom or dad's usual estate planning lawyer. That's where we kind of look at, okay, was there undue influence here or suspicious circumstances in the creation of this will? If mom or dad used to see Tammy for 10, 15 years, and then all of a sudden, even though Tammy's still practicing, suddenly it's Kim who's doing the will.
Right.
So is there a reason behind that? So I look at the will, I see if it's the usual estate planning lawyer. I meet with the client and ask them, okay, in or around the time that this will was made, what was mom like or what was dad like? Were there any capacity issues? And then we go into actually bringing the application to court. We call it an application for directions, wherein we hopefully are able to get orders for the disclosure of medical records in or around the time that the will was made. So we get the medical records, and we also get, if the will was prepared by a lawyer, then we try to get that lawyer's file as well to understand, did the lawyer think that mom was capable? Was there a capacity assessment done? That sort of thing. And then if we are concerned about the named estate trustee in this will sort of trying to get things done quickly, we could also file a notice of objection to stop them from distributing the estate prematurely. Or having what's called a certificate of appointment of estate trustee or probate being obtained. And then we review the evidence. So we go through the medical records, we examine if the doctor is still practicing, we examine the practicing doctor, we examine the drafting lawyer. It's all very fun for me, but
not so fun when someone's paying the bill.
Well, that too. And also, you've just lost a loved one.
Right.
And you're now suddenly embroiled in this dispute with a family member. A family member,
yeah. Yep, so you forget this is a family member you're generally having a dispute with.
Exactly, yeah. So then 9 times out of 10, Tammy, we try to mediate. At the end of, we've gathered all of the evidence, we've reviewed it with our client, we've given them advice on, okay, here's the chances of success. But at the end of the day, we advise our clients that, as you said, this is a family member. And beyond this dispute that you are currently involved in is still a person that you grew up with, who's, your blood, your relative. And do you really want to continue fighting?
Mm-hmm. When there's money involved, generally the answer is yes. In my experience.
Yes, so then we get into a conversation of, okay, is the money you are putting into litigation worth the broken relationship, the stress, the anxiety that comes with being involved in litigation, and all of those things. So 9 times out of 10, we end up in mediation or some sort of alternative dispute resolution where clients have more control over the outcome versus having a matter heard by a judge and you have no control.
Right.
And then there's cost consequences, not just the money that you pay your lawyer, but if you lose, then you're on the hook for a portion of the other side's fees, typically, as well. It's litigation can be very, it's costly, not just on the financial aspect, which is huge, but also for your own well-being and
the time and
your time
absolutely.
And the family relationships and all of that. So so that's typically how a case from start to finish will go.
And then if you can't come to agreement, then you start going through the courts.
And then you go through the court system, you get a hearing date, etc.
So anyway, well, I think we're out of time. So I do want you to give, what are the top 2 tips or 3 tips you would give to a family business or even an individual when preparing their estate planning, will planning, to avoid having to hire you?
We'll see an estate planning lawyer, first of all, and bring all of the information about your assets. It's not just assets that are in your name, it's also what are assets that are held jointly, Do you have any life insurance policies that have beneficiaries? What assets do you have that already have beneficiaries, like RRSPs, TFSAs, that sort of thing? Your business structure, if it's a corporation versus just a sole proprietorship, all of this information needs to be brought to your estate planning lawyer to have that robust discussion with them. And then, as I said earlier, and this goes, I think the whole overall theme of this is a plan. Every major life event, again, review your estate planning. Go to your estate planning lawyer. Make sure that things are the way you want them to be. And you can't really avoid litigation 100% because, as I think I mentioned earlier, there are mechanisms under the legislation for your beneficiaries to bring claims, notwithstanding the robust planning that you have.
Right.
But also then that goes to, especially in a family business and you're working with your children or family members, just having that honest, clear conversation about this is what I want to happen. This is who I want to take over the business when I die. And these are the reasons for all of that.
I mean, you think that by listening to someone like myself as a family business advisor and their lawyers, they would get that message that you need to discuss this in advance, not to keep it, under wraps and let them, be as surprised. I have one client that says, it'll be a shit show. I'm like, well, great. That's really good. Thank you for that. They just don't want to do that. I think it's complicated, right? It takes you a lot of thinking. You have to have a lot of hard conversations that you maybe don't want to have, which is why you've decided to do what you've done when you know it's contrary to maybe what one of your kids thought. It's very difficult.
For sure. And you mean, I like to joke with my family because I talk about wills and dying and what do we do after so and so dies, all that. But I'm immune to that because this is my world. But I totally understand the flip side of it, where it's a morbid conversation too. People don't want to think about
they don't
what happens when they die.
Yeah,
it's scary, but it's a necessary conversation.
Yes, absolutely. Well, thank you so much for coming in today. I really appreciate it.
Thanks for having me. It was a pleasure.
If you like this episode, subscribe to the Business of Family podcast on your favorite listening platform. You can also find BlueRoots on Facebook, Instagram, and LinkedIn. On the next show, I'll be back with another amazing guest who will inspire you with their family business insights. Until then, take care and keep it in the family. This podcast is for informational purposes only and should not be considered legal, tax, investment, or insurance advice. Before acting on any advice, please contact your personal or company advisors.